Happy New Year. Thank you very much for joining. This is the first In-House in Focus series webinar of the 2024 series. This is a 2023 catch-up on key contractual cases which occurred through 2023, which caught the eye of Abaigh, Beth and me. Like we did last year, we're going to run this as an interactive quiz. Where there will be a scenario, a couple of suggested answers. We'll open up a poll so that you can provide what answer you think the answer to the question is, and then we'll talk through the problem explaining the correct answer. The polls are all anonymized, so don't worry about that. There is a Q&A function as well. So if you have any questions about the questions or the topics that we're talking about, then please feel free to raise those in the Q&A text box. Again, these are anonymous to everybody on the webinar. If we're not able to deal with the question during the webinar, then we'll follow up with that at the end. We'll try and deal with those questions at the end of the webinar, however. I think just finally, just a little bit of housekeeping. This session is recorded. There will be a recording which will be posted, and we'll send the slides and citations to the cases as well after the webinar. So just finally, we'd just like to quickly introduce ourselves. My name is Mark Davison. I'm a partner in our London office. I am a commercial disputes lawyer, regularly acting for clients in contractual disputes. So many of the issues that we'll talk through today have arisen in problems that we're helping clients with. Abaigh, do you want to briefly introduce yourself?
Good morning. It's good to see you all this morning, and as Mark said, Happy New Year. I'm Abaigh Compton. I'm a senior associate in our commercial disputes team with a wide-ranging practice as well, and will often come across similar case facts to what we're going to discuss today. So lots of contractual issues that come up today. I'll now hand you over to Beth, who's also joining us.
Morning, my name's Beth Farrer. I'm a trainee at the Cambridge team, and I was in commercial disputes and helped Mark and Abaigh pull this together so that I could learn about various different types of contract disputes.
Thanks, Beth. Shall we go to the first problem?
Yeah.
So the first problem we have here on the screen is the problem of hare and tortoise. And so what we've got here is a business which is trying to provide introductory services to another. And the problem that we have here is that Tortoise has agreed to pay Hare an introductory fee of £1 million if Hare is able to introduce the third party to effectively invest in Tortoise through a capital injection, effectively through purchasing equity, through purchasing shares. The agreement, however, is contingent on the valuation of Tortoise following the equity valuation being more than £50 million. Hare manages to introduce an investor to invest in Tortoise, but unfortunately, the valuation of Tortoise, once that investment is made, is £48 million. And so Tortoise refuses to pay Hare any more money. And so Hare therefore brings a claim against Tortoise, saying that it's been unjustly enriched by the service that it's provided to Tortoise, but that it's not been effectively remunerated for. So there is no term of the contract which deals with this issue. And so therefore, looking at the three-stage test for implying terms from the 2015 case or Supreme Court case of Marks and Spencers and BNP Paribas, we've got three suggested answers there on the screen. And I think if we open up the poll, then that should allow you to set out what you think the answer to that question may be. Perfect. So thanks everybody for voting on that. The correct answer is A. So this follows from the case there cited at the bottom of the slide there, Barton Morris. And so effectively what that case concerned was an introducer agreement similar to what we have here, although I think this actually involved a property transaction rather than an equity transaction. And so what happened there was that effectively Mr. Barton was engaged by Mr. Morris to find somebody to purchase Mr. Morris's property. And the contract that they entered into was contingent on the property achieving a certain value, which unfortunately wasn't met when the purchaser purchased the property. So Mr. Barton brought a claim for unjust enrichment against Mr. Morris. And unfortunately, at the Supreme Court level, the court dismissed Mr. Barton's claim. And the reason for that was that following the test in M&S and BNP Paribas, effectively there's a three-stage test that courts will go through when they're implying terms into a contract. So the first is that in order to imply a term, a court has to be satisfied that the term is so obvious that it goes without saying, or that it will only be implied because the contract without the term lacks commercial or practical coherence. Sorry, I just had a note there from one of my colleagues. The contract lacking commercial or practical coherence, which effectively means that the court needs to imply a term in order to give practical effects to the contract. That sort of is a slight restatement of the earlier business efficacy tests, which we may all be familiar with from law school. The second stage of that three-part test is that the implied term, which the party seeking to rely upon it, has to be able to demonstrate that it's capable of being clearly expressed in the contract as an implied term. And then the third part of the test is that implied term itself cannot contradict any express term of the contract. So in Barton, at first instance, the High Court had refused to imply a term on the basis of the test in M&S and BNP Paribas, and also finding that it would interfere with the parties' freedom to define their obligations clearly in the contract. But the Court of Appeal had actually overturned that. And so it was sort of important that when the Supreme Court came to this, that it came back to sort of first-base principles about implying terms, which effectively a claim in unjust enrichment is, because you're effectively implying a term that you should be remunerated for your service. So I think, again, the key takeaway here is that if you've got a contract where effectively the benefit you're going to receive under the contract is contingent on something happening, and there is a real risk that may not happen, but you're going to effectively invest expenditure and capital in procuring that service, try and think away, is there anything around which can provide you with some form of protection? So, it's a classic example is maybe a contingent fee or an abort fee if you're engaging in services, but it's contingent on a certain event happening. The reason, just to say why I've turned this from a sort of property transaction into an investment of equity into a company question, is just to flag also just that there was a 2022 case called Kinled and Zopa, where again it was a similar fact pattern involving an introducer agreement, but actually the judge said in that case on an overture basis that because introducing equity investment into a company is a regulated activity for the purpose of FSMA, that actually introducers might not necessarily be entitled to any form of fee, given that effectively they're breaching FSMA by not being regulated but performing regulated activities. So again, it's just a cautionary tale for all of us just to be aware of whether anything that we're doing could be deemed a regulated activity for the purposes of FSMA. So Abby, shall we move on to problem 2?
Yeah, great. Thank you very much, Mark. So this problem is between Scooby-Doo Limited and Scrappy-Doo PLC. So after some extensive pre-contractual negotiations, the parties entered into an agreement for which Scooby provided a software system in exchange for monthly fees payable to Scooby by Scrappy based on the number of Scrappy's user accounts. The agreement contains a number of clauses, as you'd imagine, 3 of which are on the slide there. So 8.10 reads that payment will be made in full without withholding, deduction or set off, including in respect of taxes, charges and other duties. Clause 10.5 provides that Scooby-Doo Limited will make any necessary changes to ensure that the managed system meets the legal requirements of the territory in which the parties were operating. And clause 16.2 provides is an exclusion clause which protects and limits Scooby-Doo's liability to Scrappy-Doo under the contract, and you'll see there are a number of different sort of categories and heads of loss there that it covers. So time moves on, and Scrappy claims that Scooby failed to make the necessary changes to the software system. So and claims that this was in breach of their obligations under clause 10.5. And this has led to Scrappy suffering loss of user accounts and therefore profits. Scooby then counterclaimed for the outstanding fees, which Scrappy hadn't paid, and Scooby sought to rely on clause 8.10. As a result, Scrappy then made an application to amend its claim to state that clauses 8.10 and 16.2 were part of Scooby's standard terms and were unreasonable within the meaning of the Unfair Contract Terms Act 1997, and therefore argued that they couldn't be enforced against Scrappy. To amend its claim, Scrappy also made a connected application for specific disclosure, and they did so to attain additional information on to support its claim concerning its UCTA argument, and B, to ascertain whether it could make a new pleading of fraud or fraudulent misrepresentation against Scooby. So the question here is, which of the following reasons was the reason for the refusal of Scrappy's specific disclosure application? Was it A, Scrappy had no real prospect of success on the UCTA argument, and that conclusion could not be altered by further evidence, and in the absence of a pleading for fraud, the documents sought were not disclosable? Was it B, Scooby's breach of the legal requirement obligations had no bearing on Scrappy's loss and therefore the claim was struck out? Or was it C, that the practice direction concerning the disclosure pilot scheme does not accommodate for specific disclosure in cases related to fraud? Can we have the poll? Great, thank you. We'll give you around 30 seconds to submit your answers to the poll. So the correct answer was A. Scrappy had no real prospect of success at trial on the UCTA argument, and that conclusion could not be altered by further evidence. And in the absence of pleading for fraud, the documents were not disclosable. So this example was based on the recent case of Pinewood Technologies Asia Pacific Limited and Pinewood Technologies PLC. In this claim, the claimant's application for specific disclosure was refused. It was found that the claimant had no real prospect of success at trial on its UCTA argument for several reasons, one of which being that the parties had access to legal advice when negotiating the contract, and the claimant had proposed changes to the draft agreements, which had then been accepted by the defendants, making it impossible to determine that the agreements were based solely on the defendant's standard terms of business. So specific disclosure was also considered in the context of the Practice Direction 57 AD, which sets out the disclosure pilot scheme. And the combination of the two, so specific disclosure will only be provided or granted in the context of the disclosure pilot scheme where it was reasonable and necessary, but it must also not undermine the integrity of the disclosure pilot scheme. The claimant's application for specific disclosure in relation to the UCTA argument was rejected on the basis that the UCTA argument had no real prospect of success and further evidence would not alter that conclusion. The claimant's connected application for specific disclosure in relation to the potential fraud arguments or fraudulent misrepresentation claim was also rejected. The claimant had not included a claim for fraud in its pleadings, nor had it sought permission to amend its pleadings to include such a claim, and the documents sought weren't disclosable in the absence of a pleaded case to plead of an amended case to plead fraud. So, in its arguments, the claimant sought to argue that the disclosure pilot scheme provided a wide-ranging obligation on parties to cooperate over the disclosure of documents. This argument was rejected as it was said to go far beyond what was envisaged by the disclosure pilot scheme. In fact, it would be contrary to the scheme's literal terms and overall purpose in order to order disclosure in relation to unpleaded issues purely on the grounds that something might turn up that change the shape of proceedings. So the takeaway from this is that the obligations under the disclosure pilot scheme don't go further that so far as to allow obligations on the parties just to disclose any document whatsoever. There must be a pleaded argument. You can't use it as a way of sort of what we would determine a fishing expedition. So that's where that's helpful to limit where the documents that you're obliged to provide. I'm going to hand back now to Mark for the third problem.
Fantastic, thanks, Abaigh. Okay, so it wouldn't be a contract review quiz without a problem arising out of Brexit and COVID involving force majeure. What's been quite surprising actually since the pandemic and Brexit is actually just the lack of decisions which are coming out around force majeure and frustration arguments. So when they do arise, they're of particular interest to commercial litigators. So the problem here is we've got Three Pigs Limited and Big Bad Wolf Inc. that enter into an agreement about the distribution of certain products which are supplied by Three Pigs, effectively in exchange for a fee, and there's a minimum volume guarantee in respect of the number of units which will be supplied and transported each year. And in the event that there's a failure to achieve that minimum, then Big Bad Wolf will have to make a shortfall payment. There's two clauses in the contract. The one regarding the minimum volume guarantee is there on the screen. And the key point there really is that by 1st of January 2020, the parties are considering there may be issues following Brexit, and that if there are those issues, then what the parties have agreed is that they will attend a meeting to discuss and propose strategies to try and achieve the minimum volume guarantee. And then there is a second clause, which is a force majeure clause, which provides that if there are events such as pandemic events which prevent BBW from transporting the shortfall units, then no shortfall payment will be due. There is a problem with trying to effectively supply and transport the minimum volume. The parties meet, but there is no agreement of how to formulate a strategy to try and overcome that. And therefore, a suit is brought for the shortfall payment, which Big Bad Wolf defends on the basis that Three Pigs did not attend the meeting in good faith, and that there has effectively been a force majeure event which has impacted Three Pigs because of the withdrawal from the EU and the COVID pandemic. So the questions are, so to defend the claim, would Big Bad Wolf need to show that effectively by not agreeing a new volume at the meeting to discuss how to try and overcome the issues caused by Brexit, Three Pigs has not discharged its obligation under clause 11.3? Or is it that the force majeure event has to be more than just merely capable of affecting a supplier? It actually has to affect it. or the impact of COVID-19 and the pandemic had on travel was sufficiently a force majeure event. And so this problem arises from the case of PDT Sport, the T Sport there on the slide, and P&O North Sea Ferries. So we'll just allow 20-30 seconds just to allow people to vote on that question. Okay, so the correct answer here from the case of P&O North Sea Ferries is actually B. And so it was a first instance decision, and it was only a decision which was determining a claim brought by a claimant for summary judgment on the shortfall payment which was due under that contract. But it is interesting because it discusses sort of ongoing contractual issues which are arising out of Brexit and the pandemic. So effectively what happened in P&O Ferries was that a port operator brought a claim against a ferry operator for unpaid shortfall payments. And the defendant denied liability as it maintained that there was actually pre-agreed minimum volume of units to be transported through the port, but it could not actually meet those because of the pandemic and post-Brexit transition arrangements. They also brought an argument that effectively the claimant did not attend the meeting in good faith, in accordance with a clause which is similar to that in the fact pattern. However, the court didn't accept that argument on the basis that effectively there was no obligation under that clause for a party to attend it in good faith. Effectively, in order to provide a good faith obligation, you have to expressly provide for that in your contract, or you have to have some form of relational contract, which are long-term contracts, where the courts may imply obligations of good faith, but otherwise, typically in sort of short-term, non-relational contracts, courts will not imply terms of good faith, which goes back from sort of the case about 9 years ago, where Mr. Justice Leggett had implied in a case that there were obligations on parties to operate in good faith, but the courts have slowly been rowing back from that over recent years. If you're interested in reading a case about obligations of good faith and when they might be implied, there's a case called Compound Photonic Group Limited from 2022, which might be of interest to you. I think what's really interesting about this case, though, of P&O Ferries, is that it talks about Brexit and the COVID pandemic. And so even though Brexit was not expressly included as a force majeure event, the court did consider that in the context here, and given how wide-reaching the force majeure clause was, that Brexit would constitute a force majeure event. But in order to satisfy that, effectively two conditions had to be met. One, you have to show that the force majeure event could affect the ferry operator. And then second, you have to establish that it did affect the operator and actually prevented it from being able to perform the obligation which it was required to perform under the contract. And what happened here is that the court took judicial notice of the fact that both Brexit and the pandemic had at times impacted travel and transport, but it didn't know anything about how it was impacting the operation of freight ports in 2021. And the defendant hadn't proficiently outlined that in its evidence for the case. In terms of sort of takeaways from this case, and just for those who are looking at force majeure clauses, I appreciate in 2020, 2021, around the pandemic, everybody was quite hot on force majeure clauses and was taking a lot of attention and focus on them when they were drafting them in their agreements, even though they tend to be a boilerplate clause stuck at the back of the contract. But again, it's just as a reinforcement, really, that if you're looking to negotiate a force majeure clause, as always, just truly try and step back and think about what is it that might happen which is outside of my control, and then what happens in order for me to get the protection of the force majeure clause. I think, as I said at the outset, it's been really surprising to see how few cases there have been, or certainly judgments, which have where arguments have been raised on force majeure clauses and frustration arguments arising out of the pandemic. I think the second sort of takeaway as well is that if you've got a contract where you can foresee that you may need to renegotiate an obligation if a certain event happens, again, try and be as specific as you can to set out specifically what needs to happen. I think in a case like this, the parties might have been able to avoid expensive litigation had they expressly provided that if a certain event occurs, the next will happen. So they could have said that, you know, if the volume of freight traffic at that port decreases by X% against 2019 levels, then the minimum volume guarantee will reduce by according Y%, just so that everybody knows what playing field that they're operating on. And again, I think that would have avoided quite expensive litigation here in terms of the case in this problem. So we've got a fourth problem now, which Beth is very kindly going to take.
Thanks, Mark. So this case is on cause of action. And so here we've got Queen of Hearts Consultancy and Wonderland LLP, who have entered into a consultancy contract. It was expressly agreed in that contract that QHC would submit invoices for the work done, which must be paid within 90 days. 3 invoices were issued in 2013, which Wonderland never paid. QHC issued a claim in 2019 for the unpaid invoices, which was 6 years after issue, and argued that they weren't time barred. So the question in this case is, when did cause of action accrue? Was it A, cause of action accrued on signing of the undertaking as payment could be received from that point onwards, or B, cause of action arose 90 days from the date of the first invoice, or C, cause of action accrued when the work was done or services provided and not when the claim for payment was made. So if we could have the polls. So the answer is C. The cause of action was held to be accrued when the work was done or services provided and not when the claim for payment was made. This scenario is based on a recent case of Consulting Concepts International Incorporated versus Consumer Protection Association 2022. And this case discussed the commercial consultancy contract that was made with no provision for specific remuneration. The claimant applied for a retrospective extension of time for service of its particulars of claim. It was not clear when cause of action arose in relation to the 3 unpaid invoices, as the invoices stated that they needed to be paid within 90 days of receipt. The use of the word within in the contract suggested that the invoices were expected to be paid before the expiry of the 90 days. However, this case explored the argument of whether cause of action started on delivery of the invoice or once the 90 days had elapsed. This case also explored whether cause of action actually occurred when the work was completed. The claim was also issued 6 years after the date of the invoices, and it was maintained that the claim was time barred. The claim was struck out for the following reasons. So cause of action arose when the work was done or services provided and not when the claim for payment was made. Clarity in the wording of the contract was needed, and following the ruling in Legal Services Commission versus Henthorne in 2011, the court cannot become embroiled in collateral issues such as reasonableness of things such as delays of issuing invoices. The judges made it clear that payment had to be within 90 days, as the wording suggested that the parties had considered that payment may be received earlier than the 90th day. It was therefore found to mean that anything else would allow the claimant to indefinitely postpone the running of time by not submitting an invoice. In any event, the invoices had been issued over 6 years prior, and therefore the claim was out of time. I think I'm going to hand over to Abby for the next question.
Thanks, Beth. So our next question concerns termination, but interestingly is also our second case concerning implied terms in our webinar today. And so the example we've got here is Kermit Inc. entered into a franchise agreement with Muppets International Limited. Under the terms of the franchise agreement, Kermit was permitted to operate a retail business for the sale of Muppets products under the Muppets trade name. Pursuant to the terms of the agreement, Muppets could terminate the agreement in the event that Kermit became insolvent, failed to pay any sums due within 7 days, or otherwise failed to perform its obligations or committed a breach under the agreement. The agreement was initially signed in 1983, and in accordance with its terms, it was renewed every 5 years until 2023. In 2023, the Muppets denied Kermit's request for an extension to the term of the agreement. Kermit issued a claim against the Muppets, asking for the court to interpret the agreement and declare that the Muppets was required to accept Kermit's request for an extension. In response, Muppets sought to argue that there was an implied term in that agreement, that after a reasonable period, the Muppets could terminate the agreement on reasonable notice. So the question here is, did the court imply a term into the franchise agreement that after a reasonable time, the Muppets could terminate the agreement on reasonable notice? The answers open to you are either A, yes, without such an implied term, the contracts would run in perpetuity. B, yes, without such a term, Muppets would have no right to terminate the agreement, so this term should be implied for business efficacy. Or C, no, implying such a term would be inconsistent with the express terms of the agreement. Please could we have the poll? I'll give you a few seconds to input your answers there. And as you can see, the relevant case in this example is set out at the bottom of the screen there, and concerns the Burke Partnership and Body Shop International Limited. If we can have the next slide, you'll see that actually the correct answer is C, no, implying such a term would be inconsistent with the express terms of the agreement. So, as I mentioned, this claim, our example here was based on the Burke Partnership and the Body Shop International Limited. In this claim, the Body Shop entered into 2 franchise agreements with the Burke Partnership, allowing the Burke Partnership to run 3 shops, 2 in Norwich and 1 in Cambridge. Sorry, that's 1 in Norwich and 2 in Cambridge. The judgment provides a helpful summary of the rules on contractual interpretation and reiterated the court's hesitance in implying terms. Like our example, the agreements in this case did have an express term which allowed the parties to perpetually renew the term, i.e. every 5 years, the Burke Partnership was entitled to request that the agreements be renewed, and there was no ability for the Body Shop to reject such a request unless the Burke Partnership had not complied with its obligations under the agreement. However, the court found that this does not mean that these agreements were perpetual agreements. They could not be perpetual because they were explicitly said to be for a fixed term of 5 years, which could be extended. The court found that implying a term that would allow the Body Shop to terminate on reasonable notice after a reasonable time had expired would make a nonsense of this fixed term nature of the agreements. In addition, the court also found that such a term couldn't be implied, as the agreements had already provided the Body Shop with an express right to terminate the agreement, i.e. if the Burke Partnership became insolvent, failed to pay the sums due, or otherwise breached its obligations, the Body Shop could terminate. And implying such a term would be inconsistent with this express provision. And this is something that Mark mentioned in his example earlier, that the court will not imply a term where it's inconsistent with the express provision set out in the contract. Finally, as the agreements didn't lack coherence in the absence of an implied term, it wasn't possible for the claimant to argue that the term had to be implied for business efficacy. So on that basis, the Body Shop's claim was rejected, and they were obliged to renew the term of the agreement. I'm going to hand over now to Mark for problem number 6.
Perfect. Just conscious of time. So this one is a case that concerns MAC clauses, material adverse change clauses. So the problem here is that we've got Rapunzel that enters into an SPA to sell her company to Cinderella. The SPA is signed on the 1st of July 2023. but there is a warranty that effectively there's been no material adverse change in the company's prospects from the date of some management accounts, which are dated 31st of July 2022, so 6 months earlier. So after the sale takes place, the purchaser realises that actually the target has suffered large losses and that the turnover is significantly lower than that which is forecasted in the management accounts from the 31st of December 2022. And in those accounts, it forecasts revenues under large significant contracts, which ultimately do not materialise. So the question here is effectively, did Rapunzel breach the warranty? Is the answer yes, because turnover was lower than forecasted, and Rapunzel could not have reasonably have expected the subsequent profits to rebalance the lower amount. So effectively, it's just not been able to, the revenue is lower than that which is set out in the management accounts. Or is it that the answer is no, they've not breached the warranty because the warranty is that the company has to, effectively, its prospects must have worsened? Or is it actually C, that they haven't breached the warranty because the clause is too vague to be enforceable? Okay, so the answer is B. It's all around the company's prospects, and it's those which must have worsened. So this comes from the case which was on the previous slide called Decision Inc. and Garbutt and the Court of Appeal decision. And so what happened in that case is parties entered into an SPA with a similar provision to what we had on the slide previously, where effectively management accounts are signed, but several months before the SPA is signed. And in the meantime, there is a significant reduction in revenue. And so the purchaser brings a claim for the breach of warranty. So at first instance, the judge found that the seller breached the warranty and attempted to formulate a sort of fairly unique test around how MAC warranties should be assessed. And the reason we've raised it for today's session is that the Court of Appeal overturned that decision and said that the High Court had adopted the wrong test and tried to sort of formulate a test around how you assess these types of MAC clauses, where effectively you've got a representation being made on one date in respect of something which was dated on another date. And so effectively what the court says is that effectively you have to assess the data for the problem on the two dates. So effectively in this scenario, you assess what are the company's prospects on the 31st of December 2022, and have they materially changed by the 1st of July 2023? I think why this is sort of interesting to us as practitioners, and why we've sort of raised it here, is really the sort of the key takeaway here is around MAC clauses. I think everybody puts in MAC clauses thinking that that provides them with some form of protection. But what we find in practice is actually parties very rarely bring actions based on breach of material adverse change clauses, is because they are sort of vague and inherently uncertain. And so really the key takeaway here is that if you can, try and avoid trying to rely on a MAC clause and try and provide for a specific warranty that you're looking to try and provide for. So if you've got something important where you're relying on the historical information, like they were in this case, so some historic management accounts, and you think there's a material likelihood that might change between when you enter into the contract, just make a specific reference of what it is that you want them to warrant. So do you want them to warrant that the revenue is a certain amount, that certain contracts are still key opportunities for the business? And that way you can try and avoid expensive litigation. Just very quickly, just as a side issue in this case, the importance of notice provisions in contracts. So certain contracts have at the end, towards the end of the contracts, specific notice provisions of what needs to happen if you need to notify a claim to a party. And they will say that it has to be notified within X amount of months or years to make it shorter than the normal limitation period that you have, and that you have to communicate X, Y, and Z within that notice. And what happened in this case of Decision and Garbett is that the claimant hadn't followed that process strictly. And so what the Court of Appeal said was, because it reformulated the test around how the MAC clause should be interpreted, typically that would go back to first instance to then decide. But here, because the parties were out of time to issue a new notice under the contract and had failed to comply with the notice provisions under the contract, it said, well, actually, the claimant's out of time now, so it can't bring the claim. And so therefore, that was the end of the matter. So again, just the takeaway there is to make sure that you follow notice provisions in your agreement. Abby, do you want to take the last one regarding last bus?
Yeah, that sounds great. Thank you. So our final problem, as Mark mentioned, is relevant to the last bus case, and our facts are as follows. So Captain Hook and Peter Pan entered into a hire purchase agreement in which Captain Hook agreed to rent out his ships to Peter Pan. Over the course of 20 years, the two entered into 45 similar agreements. These agreements used Captain Hook's standard form, in which the terms and conditions purported to exclude the implied term that the goods are of satisfactory quality, that implied term from the Sale of Goods Act 1979. In 2022, Peter Pan brought a claim against Captain Hook for breach of this implied terms, as certain ships were not of satisfactory quality. Captain Hook applied for summary dismissal of the claim, seeking to rely on the clause excluding the implied terms of satisfactory quality. The judge at first instance granted Captain Hook's application and dismissed the claim, as they considered that there was no inequality of bargaining power between Captain Hook and Peter Pan, and therefore there was no real prospect of Peter Pan arguing that the term was unreasonable pursuant to the Unfair Contract Terms Act 1977. In November 2023, Peter Pan appealed this decision on the basis that the judge had erred in finding that the parties had equal bargaining power. The appeal was upheld on the basis that the exclusion clauses in the contract, based on one party's written standard terms, are subject to the test of reasonableness. The parties were found not to be of equal bargaining power, and therefore the exclusion clause was unreasonable. Which of the following was not a reason for the findings that the parties were not of equal bargaining strength? Was it A, that Peter Pan had not properly considered and understood the terms, and Captain Hook took advantage of this? Was it B, Peter Pan had no remedy, even if he received no value at all, whilst having to continue to pay for the hire? Was it C, that there were no material different terms available in the market available to Peter Pan? The correct answer was A. The fact that Peter Pan had not properly considered or understood the terms and Captain Hook took advantage of this was not a reason for finding that the parties were not of equal bargaining power. So, as I mentioned, this case mirrors the recent case of Last Bus Limited and Dawson Group Bus and Coach Limited, and it was considered by the Court of Appeal. In that case, the Dawson Group provided the last bus with 4 buses under hire purchase terms, which sought to exclude the implied term that they would be of satisfactory quality. In fact, the buses were not of satisfactory quality, so Last Bus brought a claim against Dawson for breach of contract. Dawson then applied for summary judgment, seeking to rely on that exclusion clause that sought to exclude the implied term of satisfactory quality. Last Bus argued that the summary judgment shouldn't be granted, as it had a reasonable prospect of arguing that, pursuant to the terms of UCTA, the term was unreasonable and therefore unenforceable. The judge of first instance granted Dawson's applications and the claim was summarily dismissed on the basis that the judge felt the parties were of equal bargaining power, and Last Bus therefore had no real prospect of arguing that this term was unreasonable. Last Bus then issued an appeal against the summary judgment. The appeal was granted, and the judge of first instance was found to have been wrong to find that the parties were in an equal bargaining position. It was found that it didn't matter if the parties were of equal bargaining power in relation to the price or other similar matters. The question was whether Last Bus, when they're contracting on Dawson's standard terms of business, were the parties on equal footing as to those terms. In this case, the agreement was on Dawson's standard form. It was clear from the facts of the case that Dawson would not have contracted without including this exclusion clause. And also there was no materially different terms available in the market, so Last Bus could not have chosen another supplier. As such, it was found to be arguable that the parties in this case were not of equal bargaining power, and it was therefore possible for the exclusion clause to be unenforceable pursuant to UCTA. And it was a matter that the court would have to consider at trial, and therefore the summary judgment given by the judge was incorrect. The court, however, was careful to highlight that where there is equal bargaining power between the parties, reasonableness will be likely to be found and the bargain will prevail. However, this case also showed that where exclusion clauses are included in contracts based on one party's standard written terms, including those hire purchase contracts, it's likely that they will be subject to the test of reasonableness, and the burden of showing that the clause is reasonable will be on the party relying on that term. So that was our final question, and we want to thank you all for joining us today. We hope that you found the discussion on cases interesting, and we will have a quick look now to see what questions have come up in the Q&A box.
I think, Abby, just as we're overrunning a little bit,
sure.
Shall we? We'll try and follow up with the questions separately with those who've asked them. There's been a couple which have been coming as anonymous. If you just want to follow up with an email afterwards, we can come back to you directly on those. I think just for anybody, just to come back to Abby's problem there about Last Bus and Dawson, I think for anybody that's got a business where they're operating on standard terms and conditions, where effectively you're putting those out to customers to accept, I think actually it's well worth trying to have a quick look at that Last Bus and Dawson decision, because it is sort of quite useful in respect of sort of arguments brought under UCTA in respect of where you have those sort of standard form terms and conditions. Again, apologies that we've overran slightly on this. Just wanted to say thank you to everybody for joining for the first session of our 2024 series of In-House in Focus. There will be a poll which will come up after this, just asking for your feedback. What we'd be particularly interested in is if there are any topics that you would like us to cover during the 2024 series. Actually, some of the most sort of interesting ideas do come from attendees of the series. So if there's something which is of particular interest, then please do put that in the feedback form, which will pop up after you depart. Very finally, I think the next session in the series will be conducted by my colleague Alex Newman, who is an intellectual property specialist, and he will be looking at IP risks with the use of generative AI tools, and that will take place, I believe, on Wednesday, the 21st of February at 10 a.m. So hopefully you will receive emails about that, because that looks to be quite an interesting session, especially given sort of AI and where we are today. Thanks everybody for joining, and thank you very much to Abaigh and Beth for a fantastic session. Thank you very much.